Welcome to the show. I am your gracious host, Daniel. Today is one of my favorite judges, Judge David Fleischer of Texas. I want to bring this up. I want to talk about something for a minute. I definitely want to bring this up. So let me share my screen. Michelle, sometimes you don't want to listen to people who are trying to help you. Now, I'm going to try and help you today because I think you have potential. Okay? And this is Michelle's YouTube page. You already have 1,000 subscribers. You have 1,250 subscribers. Now you need to get the 4,000 watch time hours and views. You need to stop deleting your video content. When you make a live or you make a video, keep it up there. Don't delete it. You need the views and the watch time. If you keep deleting content from your channel, your channel's not going to, you're not going to make, you're not going to be able to get monetized. Because the requirement for somebody over 1,000 subscribers is you have to have 4,000 watch time hours and I don't know how many views. Now, Michelle, listen to what I'm saying. Okay? This channel started out with nobody. It's 14 months later. I have 157 subscribers, over 900 videos, almost getting close to 1,000 videos. And I have 2,000 watch time hours. And we're at 26,000 views. Don't delete your content. Leave your content up there. See what I'm saying? Leave your content out there. When you make a video, leave the video on your YouTube page. Let it get the view. That 1 minute video, that last video the live stream that you did had over 1,000 views. That's good. That's good. You need to you need to keep making content. You need to keep leaving it up there on your page. That's the only way you're gonna be able to monetize. It's like I said, when I started this channel, Michelle, there was nobody on this channel. It was just me and Trin. Well, me and Trin, myself and Trin. Now we've gone from two people. Actually, that's right. We've gone from two people to 157 subscribers. I have over 980 videos. I think I was sitting at 26,000. We're right at 26,000 views. And I have 2,000 watch time hours. And that's from being persistent. You don't have to listen to me. God forbid if anybody actually listened to what I said. But you need to keep creating content and putting that content on your channel and leaving it there. Don't delete it. In no time, you will have the requirements to fully monetize your channel. You already have the subscribers. Now you need to put content. But enough with that. If you have any questions for the show, you can email me and I'll be glad to help you. So let's get started with Judge Fleischer's docket. And make this bigger. And here we go. Let me move this. Bigger.
Of the state of Nevada, specifically Clark County, for a robbery. And you are asking me to set you a bond. Is this right? Okay. I don't know anything about you. I'm now getting to know you for the first time. So I don't know. My primary concern is, are you a dangerous person? Because, I have so much drama in my life right now. It's ridiculous. I just don't need any more. And what I don't want to do is release you if you are a danger to my public, because I cherish that, right? I don't need any more. So we're going to find out a little bit about you, and then we'll see where we go from there. Amy, let's get to know Mr. Jefferson.
Yes, so he's wanted from Clark County, Nevada for conspiracy to commit robbery, and theft value over 100,000 or greater. The state's opposed to a bond at this time. He, as the court knows, he's being held. Well, he's not being held. He's made bond also on robbery threats in the 228th and reckless driving.
He has another robbery here?
Yes.
That's local?
Yes, it's a robbery
Open?
threat in the 228th. It is open. He's made bond on that.
Okay.
So you got a robbery there. You pick up a robbery here too. It's a robbery.
This warrant was also issued December 18th, very recently.
When was bond posted, if you don't mind on that?
Yeah, let me look.
He's actually he's on bond. He's on bond for reckless driving.
Okay.
Picks up a robbery here in September. So I guess he's on bond for a robbery here. And now he's picked up another robbery in Nevada.
I thought the robberies in Nevada were old.
He
Oh,
made
she said they were just issued 12/18.
He made the bond for the robbery threats on September of this year. That case was filed also September of this year. And then this new warrant was issued this December. His reckless driving was,
What court is that out of?
that was the 28th.
No, the reckless driving.
Oh, this one's out of court 10.
What's the court date on that?
That is
January
on January 30th.
He has a general order bond on that.
Yeah, he's made bond on that one. He also has made bond on the robbery.
And he's made court, has he made, my question is, if he's made his court appearances, Your Honor, I mean, I think he's proven that he should go on to court, showing up to court. So if you did consider bonds, he could then, don't worry about the reckless driving.
The state also wanted to add that he was just barely out of parole from earlier this year.
He was what?
Barely out of parole from earlier this year, as they have.
What was he on parole for?
I don't know exactly.
Mr. Jefferson, I got to be frank. You scare me, man. You continue to pick up cases, and they're serious cases, right? Second-degree felony. I don't know, maybe this is a third degree, but nevertheless, you have a robbery here, you pick up a robbery over there. That scares me. If I let you out, are we going to get a third one? I don't want that to happen. I know you're telling me no, but history tells me otherwise. All the open cases tell me otherwise. Now, I do have some good news for you. The good news is that you've made bond on these two cases here, so there's no holding pattern, meaning that Nevada has 14 days to come get you, and if they don't come get you, then Harris County releases you. So you have that going for you now, but I just don't feel comfortable giving you a bond. You scare me, man. The last thing I want is a third robbery. Do you understand? You got to understand from my perspective, I don't know you. You're telling me all these gumdrops and rainbows and bunnies jumping in the woods, but you've got all these 3 open cases. They're serious. Sorry, I can't, just.
Okay, he signed on Monday, Judge, so I guess,
So.
can we reset it to, what is that, the 8th?
Case, right, Monday. So 1, 2, 3 days have passed. So you got another, 12 days, give or take.
So can I get a reset for the
2, 3, 4,
8th?
5.
Is that correct? If I'm counting it?
The 7th.
The 7th, even better. Okay.
Yeah, so you said the 23rd?
He signed on Monday, the 23rd, is my understanding. So I think the 7th.
Yes, it's a seven.
So they're not gonna get you on the 7th, you'll be released in Harris County.
So they have until the 6th to come get you. Okay? If they don't come get you by the 6th, on the 7th, you'll be released. But you got to understand, even if we release you, that warrant will eternally remain open. And you could get picked up again the minute you walk out of custody. If you do get out, I would immediately go back to Nevada, take care of that. Otherwise, at some point, you're just going to get picked up again, and it's going to continue to happen.
You can hire an attorney.
And the other thing is that, right, when you do go up there, you got to let your attorney here know what the plans are so that you don't get revoked upstairs here, because then you're going to be in the exact same situation over there like how you are here. You understand? So if you go over there to Nevada and try to handle things and they put you in custody and no one knows about it here in Harris County, you have not advised your lawyer, they may think that you've just jumped ship and they might revoke the bond here, and then they'll place a hold here in Harris County because you're in Nevada. And if nobody knows, you know what I mean? So you got to let your lawyer know here.
You're a misdemeanor lawyer on your record. Do you have a lawyer for both of them, or were you appointed lawyer? Okay, so you need to tell your lawyer that if they don't pick you, you need to contact him, let him know you're in custody.
He has a lawyer in the felony, so
Yeah.
let your lawyer know in the
You
felony
need to let
case.
him know, and if they don't pick you up, you need to hire someone in Nevada, try to get you bonds on those, or you're gonna have to go out there and address them and turn yourself in and then see if they give you a bond.
All right.
So they don't revoke your bonds here, you need to let your attorney know. You understand all that? All right.
Okay, man. Good luck.
Thank you, Ron.
Thanks, Ray. Thanks, Amy.
I think that's all I have. So see you tomorrow, man.
Yeah,
Hey,
for sure.
Christian.
Dustin,
Come on, Joshua.
ready?
That's the sound of an
Wait, who do we have here?
Drake Simmons judge. It's
Summons? Simmons.
fugitive case.
Good morning, Mr. Simmons.
Yeah, I talked to Day, judge. We have a agreed bond of 5,000.
Okay. So, Mr. S-
Yeah, he just said that, you know.
you are wanted out of the state of Louisiana for a second-degree battery. Your lawyer has agreed with the state, and you are in agreement, Amy, right?
Yes, Jay is unopposed to a 5K bond.
Okay, I will set your bond at $5,000 today. You have to understand that this is the only time that this is going to happen. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. If you do that, this fugitive case against you gets dismissed. If you fail to do that, I'm going to issue a nationwide warrant for your arrest. I'm going to put your bond at 0, and it's not going to happen again. It doesn't matter what the excuse is. You have to go turn yourself in, and we're giving you enough time to do it. Do you understand? Now, the only other thing I'm going to advise you, don't wait until the last day to go, because as Murphy's Law dictates, what can happen will happen. Something invariably always happens when you go on the last day. Don't do it. As soon as you get out, make the plans to make it up there. Understand? Okay, I got you. We'll set the bond at 5,000.
He needs to have his waiver withdrawn and then also.
Yeah, it appears that he is waived, so he needs to withdraw that waiver.
Okay.
Understand, by withdrawing the waiver, you lose the time that you have by that. But so in the event that he's unable to make bonds, I don't know. That's why.
I'm getting his referral.
Okay,
Okay.
of course.
I'm not waiting for you. Wait for him.
Should we go to court 10?
I don't think they need.
I should be able to do that. I will talk.
Well, I don't.
I think you just go back to the court.
Okay. Good morning, Mr. Rodriguez. Sir, you were charged with assault, bodily injury, and criminal mischief. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You're facing up to a year on both of those cases and/or a $4,000 fine.
Judge. On December 24th, 2024, the officer was dispatched to the location and made contact with the complainant. The complainant stated that He followed the sister when she left the house to try to get her to come back. That's when the complainant ran into the defendant, the complainant's sister's ex-boyfriend, and told the defendant he could not be around his sister. The defendant walked up to the complainant really close, and the complainant pushed the defendant to get some space, and the two then began to get into a physical altercation. The complainant stated the defendant bit the complainant's left arm in between the altercation and then ran away. The complainant complained of pain and was advised by EMS to get stitches, and then the defendant was ID'd with mobile APHIS.
You said this was a sister as the complaining witness?
No, Your Honor, the sister was the ex-girlfriend of the defendant. The brother was the complainant.
Got it. Okay. Tell me about the criminal mischief.
On the criminal mischief, on December 18th, 2024, the officer was
So same day.
same day, Your Honor. No, it was before. The assault was on the 24th, the criminal mischief was on the 18th. So on the criminal mischief on the 18th, the officer was dispatched to a residence in Harris County, Texas in regard to a disturbance. The officer made contact with the complainant, who stated that the defendant broke his window with a rock. The officer made contact with a witness who stated that on the 16th, he observed the defendant throwing a rock at the front window, breaking it. The defendant was then observed by the witness leaving the area, returning to the side of the house, and throwing a bigger rock at the side window, causing it to shatter while also trying to enter the home through the window. The damage to each window was approximately $1,200.
Both of these happened on the same day, right?
No, Your Honor. The assault was on the 24th, and according to the witness, the criminal mischief was on the 16th of December. So the criminal mischief occurred before the assault.
But I'm looking at the information. The information says December 16th on both.
There is a second assault, Your Honor.
What?
There's one.
On the 31st.
Yes. Oh, okay. My apologies. I was reading because he was just picked up an assault. Let me read the assault that's out of the same transaction, Your Honor, because he picked up another assault, and that was my apologies. So for the assault on the 16th, the officers were dispatched to a Walmart in regard to service for a disturbance. The officers detained the defendant, and a search of his person revealed 0.68 grams of meth in his right pocket, and the defendant was taken back to the original scene, and the officer spoke to the complainant, who stated that he went looking for the defendant because he was a person of interest in a previous incident. While waiting for police to arrive, the defendant tackled the complainant to the ground and held him in a rear chokehold for approximately 10 seconds, impeding his breath. The complainant stated he felt pain and suffered minor injuries to his person, including a scrape on his left knee, a scrape on his right elbow, and a swollen upper lip. A witness, the complainant's girlfriend, witnessed the incident and saw the defendant choking the complainant. The defendant also admitted to placing the complainant in a chokehold.
All right, Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs and alcohol, you better address it, because I'm telling you now.
No, it's not a problem, sir.
Look at me. If it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand? I'm going to test you heavily.
That's fine.
What's the name? What is your name, sir?
Mark.
Mark. Hi, Mark. Nice to meet you. I'd like to send Mr. Rodriguez for a drug test right now, please. Stop. Don't say anything.
I consume marijuana.
Stop. I'm sending you for a drug test now. I'm gonna have you come back. I want to see what's going on. That's it.
Okay. All right.
But come back. I'll give you a lawyer today. I want to know what's going on with you so that we're both on the same page.
I can tell you.
Don't say anything. Stop. Stop. Go take the test, and I want you to come back. I'm going to appoint your lawyer today. As far as your bond conditions are concerned, you're not to have any contact with the complaining witness in this case, not to go where they live, where they work, where they breathe. You're not to be in possession of any weapons. Do you understand? If you violate these conditions, you know what's going to happen. Do you understand? All right, please. So don't worry about conditions, because I'm going to have a monitor.
Yes,
Mr. Trial.
Judge.
5,002.
I'm Christina Rodriguez. He's on today's docket.
Okay, great. Come up, sir.
And we have those results.
Great.
Hey, I'm Daniel, founder of Ridge.
Judge, David presented positive for THC, amphetamine, MDMA, cocaine, and methamphetamine.
Is there something that's not, I mean, really? Stop. It's a rhetorical question, Mr. Rodriguez, but I'm going to tell you now, it stops today.
Sure.
We're going to do this the easy way, or we're going to do this the hard way. I am giving you the opportunity for you to try to do this on your own. If you are incapable, then you're going to stay with me and we will do it the hard way. Do you understand?
Yes, Your Honor.
You will be required to test bi-weekly here with me so I know that you're not using. And if you show me that you can stay clean, then I will stop. But we will do this in baby steps. But for the time being, you're going to stay here and test a lot with me. Do you understand? I will give you a pass of 45 days on the THC, 45 to 50 days on the THC.
Sure.
But if after that time you continue to test positive for marijuana,
Right. Yes, Your Honor.
I have given you a lawyer. It is your responsibility to stay in touch with Anna. If Anna tells me she can't get a hold of you because you play games, likewise, the bond will go bye-bye.
Yes, Your Honor.
All right? Okay.
Thank you, Judge. We'll see you on
All right,
Monday.
Mr. Rodriguez, see you Monday.
Yes, Your Honor.
Thank you for the excuse.
Good morning, ma'am. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 16, 2024, officers were dispatched to a Lowe's in Harris County, Texas, in response to a theft in progress. Dispatch stated a male and female suspect had concealed items from the sales floor on the male's person, and a male threatened to hit the loss prevention officer overhead with the hammer while exiting the business. The complainant, the loss prevention officer, let the defendants exit the store and gave a description of the defendant's motor vehicle as it fled the scene. The officers made contact with the complainant, who stated he observed the defendant and the co-defendant, the male, select items off the shelf and conceal them. The defendant was using her purse to cover up items as the co-defendant concealed them on his person. The complainant confronted the defendants as they attempted to exit the business together, and the co-defendant stated he would hit the complainant with a hammer. The defendants were identified by the complainant, and the defendant's motor vehicle was searched incident to arrest, revealing several hand tools. The complainant identified items belonging to Lowe's for a total of $305.35.
All right. And I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to go to any Lowe's. Do you understand? If you violate these conditions, your bond will be revoked. It will go into custody. No more. Do you understand? Tell me, what do you do for a living? How much money do you make a month, man?
It just depends.
So are you able to hire a lawyer then?
Not at this moment, no.
That's why I'm asking you these questions.
So,
Say it again?
motor on my vehicle. So that's the first thing I need to,
How do you support yourself?
self-employed.
I need more than that.
My daughter works as well, so I don't have very many bills.
Okay, so what I'm going to do is I can give you an application, but if you just put zeros, I'm going to send it right back to you. I need to know how much money you make, how much money you have in the bank, how many cars you have. If you own a house, I need to know the value of the house. Everything I need to know. Do you understand? Okay. Do not leave until you sign our bond conditions as well, please. Good morning, sir. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 18th, 2024, the officer was dispatched to a disturbance at a residence in Harris County, Texas, and the officer met with the defendant and complainant, who are members of the same household. The officer observed no visible injuries, and the complainant stated she had been living with the defendant for 7 months. The complainant stated they were arguing in the morning, and the defendant pulled her by her legs off the couch. Complainant stated she hit her head on the coffee table as a result of the defendant pulling her off the couch, causing her to feel pain. The defendant stated the complainant had been evicted and he let her stay with him. And the defendant stated the complainant said something disrespectful, so he pulled her off the couch, but not hard enough to hurt her. The defendant said the complainant then started hitting him and he was blocking hits to defend himself.
Okay. Mr. Whittington, I'm going to find that there's probable cause to go forward with the case. Do we know whether she wants to have contact with him or no?
A rip was attempted, but there is no contact yet with the complainant.
All right. Until I know that she wants to have contact with you, I'm ordering you not to have contact with her. Do you understand?
Yes.
A protective order has been issued in this case. I would get to know it. If you violate this protective order, the state can and probably will file additional cases against you, including a violation of protective order, which is one of the worst cases you can pick up. Just don't have any contact with her and everything will be fine. Do not pick up a new case. Do you understand?
I understand.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Ramona, sign a reset. And then after that, you're on your way. All right?
Whoa.
Please, sir. Good morning.
Morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On December 18th, officer was dispatched to a driver asleep behind the wheel at 1219 Shepherd Drive. Upon arrival, officer observed a red van with the ignition on and running in a parked position in the middle of the roadway, sitting in front of the railroad tracks. Officer woke up the defendant and observed slurred speech and red glassy eyes. Defendant stated he had left a Christmas party at Club K9 and had consumed multiple Michelob beers. SFSTs were conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, and 2 out of 4 one-leg stand. DIC was read, defendant consented to breath, 0.127 and 0.127, no criminal history.
Got it. Do you see if he has a valid Texas driver license? Do you
I
mind?
can run it now, Judge.
Please. Mr. Miller, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you test positive for drugs or alcohol, your bond will be revoked. You will go into custody. Do you understand?
Yeah.
You have a lawyer. Because you have one, we will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel. If he comes back and tells me he can't get a hold of you because you're playing games, you're ducking and dodging phone calls, I will issue a warrant for your arrest.
And license is valid, Judge.
As long as you have a valid license and liability insurance in your name, you may continue to drive, but just be careful. If it does get suspended or if you don't have insurance, you're not allowed to drive.
Yes.
We good? Okay. Questions?
No questions, Your
All
Honor.
right. So I'm going to have you guys meet with the coordinator in court 6, and then you guys are good to go.
All right, thank you, Judge.
All right, guys. Happy tidings. Mr. Coleman, how are you, man? Looks like you are wanted out of the state of Ohio for robbery in the 2nd degree.
Iowa, Judge.
What did I say? No,
You're close.
sorry, Iowa. Well, not really close. Are you waiving formal extradition, sir? All right, sir. We wish you the best of luck. Thanks. Good morning, ma'am. Ma'am, you were charged with 2 counts. You're charged with possession of a controlled substance. You're also charged with theft. Looks like you guys have worked out an agreement where they're going to dismiss the, is this what you want to do, ma'am? You need to understand that this is a very important thing, that you're making a lifetime decision today, that this theft will go on your record. It's going to be there for the rest of your life. You sure you want to do this? You're giving up a lot of rights by entering this agreement. You give up the right to a trial, the right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, there's no turning back. It will stay like this forever. You sure you want to do this? All right. How do you plead to the offense of theft? Guilty or not guilty? I'm going to find you guilty, sentence you to 3 days in jail. I'll give you credit for the 3 days that you've done. I'll roll you a court cost so you won't owe anything. Good luck to you, man. Thanks. Thank you, Eric. Ma'am, we need you to come back. I do. All right. Good morning, Ms. Franks. Ma'am, you're charged with failure to identify oneself as a fugitive from justice. You're facing up to a year in jail and or a $4,000 fine. Probable cause has already been done on your case. Your case is nearly 300 days old, and it's time to do something with this case. Do you have a lawyer today?
Yes.
Who is it? She has not signed in on this case. Is she going to be here today?
She's supposed to, Your Honor.
Okay, so just go ahead and take a seat for me. We'll wait to see if she says it, ma'am. Okay? All right, do not leave. Good morning, sir. Sir, you're charged with assault of a family member. Your case is 662 days old. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 5th, 2023, officers were dispatched to a residence in Harris County, Texas, and met with the complainant, who said she had been dating the defendant for 4 years. The complainant stated the defendant had been drinking a lot and noticed his driving was unusual and told the defendant multiple times to switch so she could drive. The complainant and the defendant switched, and while she was driving, they got into a verbal argument, and the defendant hit the complainant on the right side of her face, causing pain. Once they arrived home, they got into another argument, and the defendant started throwing the complainant's clothing and belongings out of the window of their apartment. The witness was in the car with the complainant and saw the defendant hit the complainant on the back of the head, or on with the back of his left hand on the right side of her face 1 time.
Okay. I'd like to redo the protective order. Listen, one was already entered. Do we need them to do a new one? Mr. Harris, I'm entering in what's called a magistrate's order for emergency protection that identifies the complaining witness in this case. She is now a protected individual. You cannot communicate. You cannot do any family violence, assault, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon, go within 200 feet of where she lives or where she works. Do you understand? If you violate this protective order, the state can and probably will file a violation of protective order, and it's one of the worst cases you can pick up. Before you leave, you need to get to know this protective order so you don't violate it. I am ordering you not to have any contact with this person and not to be in possession of weapons throughout the remainder of this case. Do you have a lawyer today? We're giving you one today to figure out what's going to happen with this case. Your case is 662 days old, and we set cases for trial at 180. So we're going to figure out what happens with this case. I'm going to have you, well, for now, we'll just have you take your seat in the jury box. If you can reach out to the MAC, please. Good morning, sir. Sir, you were charged with driving while intoxicated, first offense. It's elevated to a Class A misdemeanor because of the high blow. So you were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 18th, 2024, the officer was dispatched to 3000 Southwest Freeway in Harris County, Texas, in regards to the defendant's motor vehicle hitting another motor vehicle and keep going. The caller stated the defendant's motor vehicle's tire fell off and that the motor vehicle was at a strip center parking lot. The officer observed the defendant's motor vehicle facing the Southwest Freeway frontage road and partially on the curb leaned against the hedge. The officer observed the engine running, the defendant's vehicle in drive, and the left front tire shredded. The officer further observed the defendant sleeping, slumped over the steering wheel, and a strong odor of an alcoholic beverage, bloodshot eyes, slurred speech, and the defendant, upon waking, had poor balance requiring the officer's assistance. The defendant stated he consumed 2 mimosa beverages and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and consented to breath. The results were 0.169 and 0.162.
Got it. Any prior DWIs and
No, Your Honor.
license?
Eligible.
Okay. I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using, I'll put you in jail and I'm going to revoke your bond. Do you understand? What do you do for a living, sir?
I currently don't work. I got assaulted recently. I lost my job.
Where were you working? What were you doing?
I was a Uber and I worked
Why stop? You still need money. How are you getting money?
I had to do light recovery. They laid me off.
Okay. Did you want to apply for an appointed lawyer, sir? You're going to go hire a lawyer.
I can't afford one. I need a.
That's what I'm asking you. Did you want to apply for an appointed lawyer?
But I will. I'm not.
Do you want to?
Yeah.
Okay. If you mind, I'm going to give you an application. I need you to fill it out. I need you to fill it out in its entirety. I need everything. I need to know everything about you. I'll take a look. If you qualify, I'll provide you with a lawyer today. Does he have you said he has a Texas driver license, right?
I see an eligible license, Your Honor.
You don't have liability insurance, then you're not allowed to drive. That's car insurance. If you don't have it, don't drive. I'm making that a condition of your bond. You must have a valid Texas driver license and liability insurance in your name. Do you understand? Okay, I'll have you fill out the application, Stephen. I'll have you sign a reset, and then we'll have you take your seat in the jury box. No alcohol, no dope. After you're done with that, you'll meet with pretrial services, so they'll go over your bond conditions. All right? Good morning. Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 16th, 2024, at approximately 12:48 a.m., officers were dispatched to a major crash at the 6100 block of Richmond Street in Harris County, Texas. Upon arrival, the officer made contact with the other officers who had advised that when they arrived on the scene, the defendant, the sole occupant of the motor vehicle, had crashed into the ditch. Upon contact with the defendant, the officer observed bloodshot, watery eyes, slurred speech, and a strong odor of an alcoholic beverage. An inventory search of the vehicle revealed 1 bottle of whiskey under the front passenger seat, which was 2/3 empty. Standard field sobriety tests were attempted, HGN 6 out of 6, the walk and turn was refused, and 4 out of 4 on the one-leg stand. The DIC was read, but the defendant refused. A blood search warrant was signed and executed.
Can you run his criminal history, please? I'd like to see if he has any other DWIs.
Your Honor, there's no prior DWIs.
Is there an allegation that he was allegedly consuming alcohol while he's driving?
No, Your Honor, they only found a bottle under the passenger seat, not cold touch or anything like that.
Mr. Nesbitt, I'm going to find that there's probable cause to go forward with your case. Have you run his license to see if he has a Texas driver license?
It's eligible, Your Honor.
All right. I'm ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go to jail. No more PR bonds. Do you understand, sir?
Yes.
Okay. You have a license. You're not allowed to drive unless you have car insurance as well in your name. I'm making that also a condition of your bond. Do you understand?
Yes.
Do you have the ability to hire a lawyer, sir?
I'm sorry?
Are you working? What do you do in life?
I'm a mechanic.
What kind of money?
afford an attorney.
Do you want to apply for an appointed lawyer, sir?
Yes.
Okay. We'll give you an application. I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. I need to know everything about you. And if you qualify, we'll appoint your lawyer. But just remember, don't consume alcohol. Don't use illegal drugs. You understand, sir?
Yes.
Okay. Stephen will give you the application. I'll have you sign a reset with Ramona, and then we'll have you take your seat in the jury box, sir. Did you want to talk?
Yeah, Judge, I've got a case, Derek Adams, on the docket. He was supposed to complete 2 classes by today.
Not do it?
No, he did, but he didn't pass one of them. And the contract doesn't require passing, it just requires taking. And so, Miss Saba, hey,
Judge,
contracts.
I just needed chief approval that that's sufficient. I've never been in this situation. Like, I don't know if I can dismiss a case for failing an effective decision-making course, but attempting
Get
it.
this, Judge. There's not a single chief working today. So it seems like there's not really effective.
So let's roll it to tomorrow, have him take it again.
I'm not coming back here.
Zoom in. That's why I have Zoom, to make it easier for you.
That's true. I'm appointed. Money's really tight for him. The
Case
contract
is 1,292 days old. We've given him how much grace to get this thing done over and over? Really?
And it was just 2 classes, Judge.
Last time, if you didn't have it done, you didn't have it passed, I'm carrying you day for day.
The contract doesn't require passing. I mean, I'm actually serious about that. Although it's funny.
I would be hard pressed to find a chief that's going to acquiesce to that. I mean, really, I don't know.
It was it was a pretty good PTI offer, Judge. It was just effective decision-making and a gun safety class, both of which are 2 hours. The effective.
It's a 2-hour class, right?
Costs $22, I believe. There's no reason he shouldn't be able to do it again.
Just, a lot of times they don't take it seriously. So let's roll it to tomorrow, have him do it again, and then let him know we're going to redo it day for day until he gets it done. At nearly 1,300 days, I have no sympathy for this person.
What's the term? A collateral estoppel or something like breach of contract? It's not my bag of chips.
Remember, they're the ones that have the power to dismiss. I don't.
Right.
They're the ones, I just sign it. They're the ones who actually file the motion.
I know that.
So do we know when is she coming back?
I mean, Kelsey won't be back till Monday, Judge.
Okay, so let's roll it to tomorrow.
Yeah.
Have him take it again. Maybe he'll pass it this time. Tell him to pay closer attention. It's only 2 hours. It's not much. If he doesn't want to do it, okay, I'm just going to roll him to Monday. I'm going to keep doing it. It's 1,300 days. We got to take care of this thing.
As long as I have a chief tell me that the attempt is fine, like I just can't make that call, Judge.
Did you see how good of an attempt it was?
He failed it. It was like a 50%.
Somewhere around 57.
So
I'm rolling it to tomorrow.
is there a possibility that we're gonna have a chief?
No.
As long as there's another chief.
But if he passes, it gets dismissed.
Yeah, and I can ask another, if our bureau chief is here or one of our deputy dogs, I can go ask them after docket, Judge.
It's up to you.
Oh, I've been around everywhere. There's no chiefs.
Well, I mean, they would be on the 5th floor, Judge.
Yeah, well, regardless, I mean, we have a lot of work to do. We have 3 other courts that we need to cover as well.
Yeah.
So have him try it again tomorrow. If he doesn't want to do it, then we're just going to roll till Monday. Yeah, really.
Thanks,
Is
guys.
he here?
He's here, yes.
Adam?
Come on up.
How you doing?
Hi. Hi, Joe.
Hi, Judge. Nice to see you.
Merry Christmas, sir.
Merry Christmas to you, Your Honor.
What are you doing with your client?
Yeah, yes, sir. I did talk to him about the most recent offer that came in this morning. And the ZA's not here, so I can't really respond back to her on some evidence. So we were going to go on.
Judge, she emailed me this morning. She's looked at the mitigation packet that defense sent, and she emailed me this morning telling me what her offer is. So everything that I relayed to her is her latest update.
What is the offer?
It's a 9-month deferred, Judge.
Yeah, and Your Honor, one of the things is just from reviewing this, it doesn't appear that the mitigation made clear enough, or they didn't take very seriously the statement that the house that the complainant and her mother's living in right now is owned by my client. He's the owner of that house. And they are living there because he's allowing them to live there. Now, he's charged them rent before, but he has not moved to evict them. He wants this process to end. But somehow from the notes that they were reading.
What's your client's name? What is your?
Hudlow.
Hudlow.
Hudlow, H-U-D-L-O-W.
Yeah.
And
the problem is that it's really old.
Your Honor, and I've discussed that with them. And so they're willing to keep, he wanted to talk to Mr. Garza directly. I've been back there calling for the last 30 minutes, if not longer, trying to reach him.
What we can do is I can give you till Monday, but it's plea or trial on that day.
Yes, sir.
Mr. Hudlow, come up.
And Judge, the state's offer is gonna stand. I mean,
Come around this way, sir.
Y'all, you can get.
All right. Good morning, Mr. Hudlow.
Morning. Merry
You
Christmas.
got to understand reasonable minds can differ. just because you want something a certain way doesn't mean that it's going to happen. In life, it goes like that in every aspect. You know, when you're buying a car, when you're buying a house, whatever it may be. You know, he can't control the offers as they're going to give. He can only tell them merely what, you know, he is given a certain set of facts and he has to work with those facts. Sometimes they're good facts, sometimes they're not so very good, but it is what it is. Now, our case is old. It's 210 days old, and we set cases for trial at 180 days, and I have no idea how this got to be as old as it is now, but it's time to make a decision. Now, your case, they have offered you a 9-month deferred, which is a type of probation that if you successfully complete, you do not end up with a conviction on your record. You can't tell people it was dismissed because it's not dismissed. It's merely a probation that you took. If you complete successfully, you don't end up with a conviction, right? But that's the offer that they've made for you, and it appears as what the state has said, that it's going to stand. Look,
Happy with that. Oh, I'm sorry.
you don't have to make a decision today. If you want to make a decision today and you want to be done with it today, we can do that. But I can give you one final setting to Monday if there's other people that you want to talk to. It's up to you, but it's time to put this baby to bed once and for all. So I will give you the opportunity now to talk to Joe to see if that's something that you want to accept now. If you need a little bit more time, I can give you until Monday. But at that point, you must either accept the plea bargain agreement or I'm going to set your case for trial because it's just too old.
I haven't had a chance to talk to Eric. Can we set it for Monday?
Okay.
I'm not saying that, you know.
No, look,
Actually, I would go
you
with-
don't have to say anything. I'm happy to do that, but you get no more resets after that day. So if you're unable to get a hold of him or whatnot, I don't care. You need to be diligent in getting together with Eric to figure out what you guys want to do with the game plan. Take a look at all the evidence, and then you make an informed decision at that point. But there's just no more time after that. All right?
Yes, sir. Yes, sir.
And I'm sure that Joe can try to get you, help you get with Mr. Garza, okay?
Because I don't know with his vacation schedule, you know, I don't want to put anybody out, but that's kind of how I think we ended up here.
We have too much.
Thank you, sir.
All right, guys. Good luck.
Thank you.
Joe. You ready?
I'm ready.
All right, come on.
Mr. Vander's license.
So this is with,
No, that's not it.
it's without the grade, right?
Yes, I told him to put it up there,
Okay.
and these are the enhancements, they said to abandon those two that are to the bottom. Just the retract, and it was 180 days.
So
Yes, Judge?
he had an open container of alcohol in the car too, though?
Yes, the surveillance shows that he hadn't been driving from 8:15 to 11 PM, and the car was also smoking at the time they.
Tell me what happened in this case, because I don't know anything about it.
I can.
I mean, if defense.
No, but I want,
Okay.
please, read to me the dims.
Okay, Judge. My computer's been slow today, so my apologies.
It's okay. I want to know that I'm making the right decision. Mr. Vanderslice, I take public safety extremely serious. I don't care who you are. I don't care what color you are. I don't care if you're a small farm animal. My only concern is public safety, and if you leave a wake of death, that's just not a good thing, and now you've got a DWI. They're saying that there's a prior DWI. You've got alcohol in the car as well. I mean, when do we say when? Now, I don't know specifically what happened in your car. I'm just looking at the allegation here.
Prior DWI, if the judgment on DIMS or
one of-
NCIC is incorrect.
Well, one of them was reduced to a reckless, Judge, and the other one in Dallas was dismissed because he was convicted of murder.
So it's a third DWI.
It was, yeah, the other one was unrelated.
Go ahead.
On June 7th, 2024, officers were dispatched to the Circle K parking lot where they were advised of a white GMC Sierra. The officer observed the car partially in a stall, and the defendant was the driver and lone occupant passed out behind the wheel. The car was running and the defendant had his foot on the accelerator. The vehicle was in park. The officers woke the driver, who was extremely slow and lethargic, had slurred speech, watery eyes, a strong odor of alcoholic beverage, an unsteady gait, and had to be guided back to the patrol vehicle. 2 bottles of Crown Royal Apple Whiskey were located in the car. One was empty and one had a little bit left. The defendant said, "I'm not going to do anything to incriminate myself" when asked to do SFSTs. The DICs were read and a search warrant was executed and blood was drawn.
There should be a additional part to the probable cause that talks about the surveillance now.
I'm going to give you opportunity to say your piece, but so initially with this case, you went up and they had offered 270 days in jail.
365.
It was 365. And the reason is because you have a murder case. There was a prior murder case. Did you do time in TDC because of it?
Yes, sir, I did. I did 6.5 years on a 10 and they let me out for good behavior.
Okay, no, that's, and then not only that, but we have 2 prior DWIs as well. One was reduced, one was dismissed pursuant to the plea bargain agreement. So
2010, I think. 27 was the date of the offense, murder, the case that he had. And then that had nothing to do with the DWI.
The DWI was in 2009.
I sent a letter to everybody explaining, our agreement from before, which was a 2-year probation based on having looked at all this stuff. And then they re-looked at it and they said that they would be fine with the TRAS recommendations. But the reasons why I think they tripped it up is it looks like the murder and the DWI were at the same time roughly, but not part of the same transaction. So the DWIs had nothing to do with anybody dying. That was a sort of a bad.
sure, I mean, so while he's on bond for DWI, he picks up a murder case, or is it vice versa?
Murder, he picked up a DWI case, I think is the, but it was at his aunt's funeral. And the problem is because he's been convicted of murder, the girlfriend wouldn't let him stay at the house, and he had a hotel. His wallet got stolen, so he was sleeping in the parking lot. And that's when he drank, when he went to sleep. If you look at the offense report, it does fill in a supplement after Mike and I talked. The officers went and looked at the surveillance. The surveillance, his car is not functional, and at night the lights don't work. So he had to park before it got dark. He couldn't stay at the hotel. He parks in a parking space at the convenience store, drinks, falls asleep, gets up to go to the restroom at like 10:30, which is 2 or 3 hours later. So the car doesn't move while he's drinking his Apple Crown. The car doesn't
Do
move.
you have that on video so that we can
That's on
verify
video
that?
surveillance.
Have you seen that?
I believe he looked at it with Kelsey. Is that what you
I've
said?
looked at it and it's in their stuff, but it's also in the police report. The officers looked at it and they put it in the DIMS as a supplement.
You take a look?
Yeah, at least the DIMS I read. So, and it says from 8:15 to about 11:03 when they came there that he did not drive his car. And that's when he says he sat in the parking lot and drank the liquor that he bought at the liquor store before 9 o'clock, obviously. And
So you're telling me that he pulls up to a liquor store?
he pulls up to a convenience store.
Convenience store.
Correct. And
buys the whiskey
buys some whiskey because
at Circle K?
No, it's a different store. So he pulls up to the liquor store before 9 o'clock. Then he pulls up to the Circle K at 8:15, I believe, or 8:30.
So how do we know he's not drinking?
So Judge, the supplement says that officer also swore the video at the Circle K shows the defendant entering the parking lot of the store in his motor vehicle at 8:20 p.m. on June 6, 2024, and officers arrived on scene at around 10:50 p.m. on the same day. So they see him driving into the parking lot.
How do we know he's not drinking before he pulls into the parking lot?
Well, that's why I'm pleading. But, that's part of the reason. Obviously, his car doesn't move for the time he's in the parking lot. But he told me he bought the drinks before when he found out he could no longer be in the hotel. And that is because his lights didn't work due to an accident that his car had. he had to shut it off before it got dark. So he parked, he had nowhere else to go.
So there's no accident in this case?
There's no
injury?
accident
No,
in this
Judge.
case, no. He had nowhere to go because of the murder conviction. He can't stay with his girlfriend when she has her kids.
Are you still on parole now?
No, sir.
Yeah, it was a 5-year offer from the state. It had to do with a roommate and a fight, ironically, over he was trying to prevent the roommate from driving intoxicated. But it not really a roommate, but it was a guy who was.
So do we really have to abandon the first paragraph, right? Because he said that in the Panola County, that's not a DWI conviction,
Yes,
correct?
Judge, that's
Yeah,
correct.
Okay, so let's abandon the first paragraph. The second paragraph, are you wanting to abandon as well? That would make it a mandatory 5-day minimum if we don't abandon.
Yes, Judge, and because we agreed, we came to you without an agreed rec, and we said that we would do what TR as
If you
recommended.
be true to this first paragraph here, that would make it a 30-day minimum.
Which paragraph? Yeah.
The murder,
No, I think the intent was to abandon that one.
Yes, Judge, so
abandon all three.
not the last one as well?
Yes.
That would make it a mandatory 30-day minimum.
Yes, Judge. I don't.
50% of people in this country don't live within driving distance of a Whole Foods, and even more of them can't afford the premiums, even if they do.
Nick Green and his co-founders came up with the idea.
All right, Mr. Vanderslice, what you're doing now is you're entering into an agreement with me, and you want me to punish you as far as pleading guilty to this DWI conviction. You need to understand that this is a lifetime decision that you're making today, that once you plead guilty, there's no turning away. You give up so many valuable rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charged read in open court. If you're not a citizen, or you can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you plead guilty, you can't take it away. You have not been able to come up to an agreement with the state. The only other option is to either set up for trial or come to me if they waive that the ability to go to trial and to come to me for punishment. And they have agreed to do so. Do you want to come to me for punishment?
Yes, sir, I do.
Okay. How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Well, I'm pleading guilty, sir.
Okay. I'm going to find you guilty. The idea is that, how old are you? You're 52.
Sir.
When does it stop? At what point do you learn? At what point do you say, I can't, I got to stop. How much money has it cost you over the years? How much time has it cost you over the years? I can't.
Shannon, I totally agree with you, and I have stopped, and I am done, and I am stable in all directions at this time, and plan on staying that way and not disrespecting your county at all anymore. And you never see me again in this courtroom.
Everyone says that.
No.
The thing is that words mean nothing today, man. I get it that maybe in 1890 business was done on a handshake, but handshakes don't mean squat now, because people now, they don't think of consequence. They act without thinking, if I do this, what's going to happen? If I say this, what's going to happen? They just act. They shoot first, ask questions later. And in life, you got to know when to say when. Shit is always going to happen in your life. You're always going to step in shit, right? But the idea is that you scrape it off your boot and you walk on, because it's going to constantly happen in your life. Something is always going to trip you up, whether someone dies, whether you lose your job, whether your wife cheats on you. It's always going to happen. But the idea is to figure out how to cope, how to deal with it, how to deal with the anger when it comes to you, because you're going to get angry. this agreement that you're getting with us today, you're pleading guilty to 180 days in jail. I'm going to put you on probation for 2 years so I've got you next to me for the next 2 years.
Yes, sir.
And what we want to see is how do you deal with the anger? How do you cope with the loss? Because it's invariably going to happen, whether you lose your pop, your mom, your girlfriend, someone cheats on you. That's how we need to cope with it. I got to imagine prison must have been one of the worst experiences ever, was it not?
So I was raped in prison.
And yet that now we have more, it sucks. Prison's not a great thing. It's supposed to be bad. It's supposed to teach you not to come back.
I'll never be back again.
I bet you said that when you pled to the murder case. How much do you want to bet you said that on the murder case? I'm trying to make a point.
Sir, I understand.
The point I'm making is how do we reach you so that when you get angry again, when you get hurt again, you don't reach for a bottle, you don't reach for some kind of hardcore drug, get into a car and kill someone. All I'm asking you to do is don't take another life.
I will have the proper coping skills for any type of anger that comes in my direction for any reason.
Would say he's done a few things while being out on bond to show that his words are backed up with actions.
What has he done?
He hasn't tested positive. He's blown in the machine. He's
that's good. That's great.
Put his life together.
Good.
He's actually off. His doctor has changed his medication because of the quitting drinking has helped him with some mental problems. He's noticed that he's sought out help. I think he's working on an IOP, and he's done a lot while on bond, but mostly just stopping and seeing what his life turned into after he stopped, and he sort of likes it. And yeah.
That's all we ask. I every single person that comes up here, $40 to $50, one button, wherever you want to go, Uber will take you.
Right.
I routinely take, when I go out with my wife, because I like to drink,
Yes, sir.
I take an Uber everywhere. So I know I don't end up on the other side of this bar as well. As part of the agreement between you and I, you will be doing a repeat offender DWI education class, Thinking for a Change, 4 victim impact panels. No drugs, no alcohol, substance abuse treatment. There is a no breath test refusal. So if you are pulled over in a car and an officer asks you to submit to a breath test, you must do it.
Yes, sir. I have a lifesaver in my unit.
But if you get pulled over and an officer asks you, that's what I'm trying to say, you have to submit to it. You must maintain a guardian interlock, no drugs, no alcohol, a $150 one-time donation to Mothers Against Drunk Driving, intensive outpatient treatment followed by supportive outpatient treatment.
Sure.
Imagine being
Thank you for being so forthcoming. Not everybody is, and I truly appreciate it. And all we want to do is help as much as possible. And it's what we like to do. We want to see you succeed, believe it or not. We want you to, walk out of here leaving better than you came. That's the idea. So that in the future, when you're confronted with these issues, you think before acting. That's all we're asking.
Sure.
All right. Do you have anything else that you guys wanted to add?
No, Judge.
Okay. Anything else?
License suspension or?
Say it again?
License suspension or?
No, because it's a true first, right? It's a true first because the first one, so I'm not going to suspend the license now. I want you to understand though, is that if I find that you drink, I'm going to put you in a rehab facility. There's no ifs, ands, or buts. I don't care if you're kicking and screaming and you got George coming up here just bitching and hollering. I don't care. If you consume, and I don't care where it's coming from, I'm going to put you in a rehab facility. If you violate this agreement, I will issue a warrant for your arrest. I'm going to put you in jail. I'm going to deem you a public danger and I'm going to make your bond so high, you're going to go nuts. And then into a rehab facility, which is at a minimum 9 months if you respond well to treatment. Do you understand?
Yes, sir.
All right, Mr. Van der Slice, we wish you the best of luck. I'll find you guilty. I'm going to follow the agreement, send you to it. Yeah, what do you do for a living, Mr. Van der Slice?
I'm an auto broker, sir. I help people, families that are facing in Houston gain access to vehicles.
And how much money do you make a month? Okay. The reason I'm asking is because of the DPS fines and fees and surcharges.
Yeah, he's basically indigent. I mean, part of the problem was he was living in his car. So it wasn't a hotel room where he can just stay somewhere. He does have somewhere to stay most of the time now.
Jen, the state, obviously it's up to you, Judge, but the state would be willing to forego the $150 donation to MAD.
No. That's part of the agreement that's going to stay, right? But let me do this. I'll have him fill out an indigency affidavit because I want to know.
Sure.
Be honest. Express my extreme disappointment with you. You've now picked up a new case. Is it on docket today or no?
It is, Judge. We placed it on after we spoke.
Mr. Foster, you now stand charged with the offense of assault. You are facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. For some reason, I don't see it.
Well, Your Honor, it's under Smith.
Well, Judge.
Tristan Smith. I'm sorry. I called you Foster. I meant Smith.
The new ADI was a 2B, so this is a walkthrough on the new case, the new charge. The previous one, which is the AFM, because he has 2 open misdemeanors right now.
Right. So he initially had the open assault of a family member.
Yes.
As of December 19th, he's now picked up a new assault.
Yes.
All right. Let's do probable cause
On the new assault.
on the new one.
Yes, Judge.
Ridge is back with our 6th.
On October 29th, 2024, an officer was assigned to investigate an assault that occurred on the 18th of October at a residence in Harris County, Texas. The officer reviewed video footage of the assault that showed the first complainant and the defendant engage each other in a physical fight until another female assisted the defendant by punching the complainant and grabbing the complainant by her hair. The female swung the first complainant to the ground by her hair, causing pieces of her hair to be ripped off while the defendant punched the first complainant multiple times in the face. As the first complainant was on the ground, the defendant stomped once on the back of the first complainant's head, and the officer observed the first complainant with injuries based on photos. The first complainant told officers that on the day of the offense, the defendant told her that he was going to assault her once she exited her vehicle, and a friend of hers that was inside the vehicle recorded the fight. The defendant and the first complainant used to be friends, and the defendant used to live with the first complainant at her residence until the defendant was kicked out.
Judge, if I can, just utilizing the state's information that they provided, I didn't hear the prosecutor read this part, but at some point, the officer interviewed the complaining witness in the new assault. based on what she told him, is that she had heard that Mr. Smith was going to attack her. And if you just read in the DIMS, she exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. When I talked to Tristan about this last week, he told me all about it. He said, I remember this, because it is a 2B. He hadn't heard nothing, any follow-up on it. This young lady got out of her car and attacked him as he was walking down the street. It says it right here. MB exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. She's in a car where she could have easily seen him and kept driving. No, she got out of her car and attacked him, exactly like he said. And while he was defending himself against her, another individual, another female, came to assist him in this fight because he was attacked and blindsided. This is exactly what the complaining witness in this case told the police happened, except she said that, well, I heard that he was going to attack me, so I jumped out my car and attacked him first. That's not an assault.
I don't know. All I know is that the facts are pretty egregious. And I mean, he could have taken off, didn't have to sit there and didn't have to engage. He could have, you're on bond for a criminal case. So stop. I'm not asking you to say anything. You, in the correct mindset, I am having open assault. It's probably a pretty good idea for me to go away and not do anything here.
And if he had that time to reflect in that instance, then perhaps he should have done that. But he's walking down the street and this girl jumps out the car to engage him in a physical fight, like she told police that she did, to defend herself from him. He doesn't have time to sit and reflect, oh, I got a case and all.
He could have run away. He could have gone. He could do something else. I don't know.
Being attacked, Judge, I mean, you got to do something.
Look, I get that there's always two sides to the story. But I mean, I'm going to find there's probable cause now.
I understand.
If you develop something later, if you see something on video, if you show something that she's the initial aggressor, come back and we can talk.
She said it. She told the officer.
I don't know that for sure. I mean, it just,
Let's say in self-defense.
Yeah, we have in self-defense, and then we have furthermore that once the female was assisting the defendant, that the defendant continued to assault the complainant, even stopping the complainant on the head.
You got to stop her if she's attacking him.
Judge, she was down on the ground. The complainant was down on the ground and the defendant stomped on her face.
I'm finding that there's probable cause. You picked up a new case.
And we'll deal with that, Judge. But the biggest issue, of course, is the fact that he did pick up a new case, albeit he didn't ask for it. I mean, he's walking down the street. And his situation being one that's extraordinary, one that I haven't seen much this year, dealing with indigent defendants, being of his age, which is a high school student, as we've talked about before, pending graduation with an acceptance to a great school. This is a very tenuous time for him. You've already ordered him to be drug tested before and all of that. So we're working through those things. The last thing and I know we have to consider the complainant witness in the community and all of that. I understand that. But I'm advocating for Mr. Smith.
I get it.
Mr. Smith has a final on Monday that he must take. If he does not take this final, and he's again in high school, then he may not graduate. If he doesn't graduate, then we can kiss Baylor goodbye. It's not likely to happen for him in light of all of the challenges that he's dealing with. He doesn't have his mother to help him. His grandmother, we know she's a complaining witness. He can't even go around the house. He doesn't have any help right now. He's living with a friend and walked here from Atascocita this morning, which took him 9 hours. I mean, this situation it's extremely difficult, Judge. So my ask is that we do something, and it could be amend bond conditions, but to keep him on bond so that he can take his test, do what he needs to do to finish school, and hopefully we can resolve these issues. I've looked at the evidence that the state has submitted for the new case. There's clearly something happened, clearly. I mean, and I would see the evidence shows that. But if he's walking down the street and this girl, per her own admission, jumps out her car to engage into a physical altercation with him to defend herself, that doesn't make sense. And that's not really fair to him. Someone that's on bond, and everybody knows he's on bond because she said, I knew him. We used to be friends.
He could have walked or run away, gone to a store, called the police. There were a multitude of other options you could have done. You know what's at stake here, yet you pick up another case where you allegedly stomp on someone's head. And you want me to let you go? I understand that you have school. I don't know that you have a final on Monday. Am I supposed to take your word for it? No. All I know is that you are a danger to my community. You have one assault. You have had violations on bond while you're on that assault, and now you've picked up another assault. You are a danger to my community. And there's only one thing that I need to do, and that's to put you in jail because you refuse to comply with bond conditions. And I've given you over and over. I appreciate your tenacity, and I love that you're defending zealously, but I can't let him go. It would be enabling this behavior and telling him it's okay for you to do what you're doing. And it's not. It's not okay to sit there and stomp on someone's head.
And Judge, we anticipated that possibility. I'd ask in the alternative that you consider a very low bond, as my client has approximately $100 to his name, being a child, in my mind, a person that hasn't even graduated from high school.
State of Texas, what do you think?
Judge, we would be opposed to that. I mean, given the egregiousness of these facts, we believe the defendant is a.
I won't do the normal. What I normally do is I set bonds at 5,001 when you pick up a new case. I'm willing to go down. I'm not going to give them $100 bond because that's what we do on new cases.
I'd ask
And
for.
I think that that's a little.
So we're going to revoke the previous bond. That was a personal
I will
bond.
only touch the old case.
And so we'd ask that, well, I didn't anticipate that you would set a personal bond on the new case. So I guess my request would be two $500 bonds.
Oh.
I mean, we're talking about a misdemeanor assault between children, not a.
Well, I don't know that. I mean, you're putting in stuff that I have no
The
idea
state
about.
alleged a misdemeanor assault. They didn't allege an aggravated assault, which they could have, and they did not. They alleged a misdemeanor
Doesn't make me
assault.
feel better.
Well, I mean, the state says, alleges that there's all this injury. We can see what the injuries were. You see the plaintiff witness in the picture. She's smiling.
Did you go to
she's
the
talking
hospital?
the police. No, she didn't go to the hospital, Judge.
I don't know.
I've read everything. She hasn't gone to the hospital. She has a swollen eye, is what she has.
Judge, I don't believe, I mean, her hair was also ripped out, Judge, based on what we see in the four corners of the dims. We haven't done.
I don't know. I mean, there's a lot of people who wear different types of hair.
Sure.
So,
But just going off the dims, we have her hair being ripped out and being stopped. So
And to your question, not hospitalized, Judge.
so here's what I'll do.
Judge, just if I may add, even in the first AFM, Judge, the complainant has gone back to the home at least once, to my knowledge, based on my communications with the complainants on that case. The defendant has gone back to the grandmother's homes. Contrary to the bond conditions and the no contact orders in that case, he's repeatedly, time and time again, violated his bond conditions, and now so we would be opposed to anything less than $1,000.
Yeah, I know. So what I was going to, his bond on the first assault it's $1,500. I'll do 2501 on that. Okay, I'll only raise it at $1,000.
If you can hear people talking but can't understand.
On the new case, what do you think? Should we give him a PR bond?
Judge.
No, Judge.
We'd be opposed based on the nature of the allegations where he stomped on someone's head, pulled her hair, and in addition to that being picked up just a month after the previous AFM.
And charged with a misdemeanor. I mean, if the state felt so vigorously about this case, then they would have filed it in district court. I mean, this is a misdemeanor assault between.
I think there's no way this would have been gone upstairs,
I agree. And which is why I think a personal bond could be adequate in light of the fact that he would be given a surety bond on his previous case. He doesn't have much of anything. If anything, that keeps him in jail until we get to trial, because that would be a case that we would set.
All right, Mr. Brooker, I'll set the new one. I'll set it at $500.
Thank you, Judge.
I hope you get it. You're going in today, but I hope you get it. I mean, we're not going to stand for this. You got to pay the piper. And I don't know if it's dealing with the school now will get you to wake up and realize that you can't do what you're doing, but that's it. I've literally bent over backwards not to put you in jail. Mr. Smith, literally bent over backwards. How many chances have we, Yeah, goes with you. Okay, Mr. Smith, good luck. Ma'am, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer was driving on Katy Freeway in Harris County, Texas, when he observed the defendant's vehicle driving at a high rate of speed, rapidly accelerating, making evasive lane changes and aggressive maneuvers without signaling, cutting off multiple vehicles, and making those drivers take evasive action to avoid a collision. While the officer was attempting to catch up to the defendant, he reached speeds in excess of 120 miles per hour. The officer then conducted a traffic stop, and the defendant stated she was driving that way because she was late to work.
And I'm going to find that there's probable cause to go forward with your case. Do you see if she has a valid Texas driver's license? Okay. If I find that you drive like this again, because I'm making a bond condition that you're not to drive like this, if I find that you do, I will take your privilege to drive away from you while this case is open. Do you understand? Living in a city as big as Houston without the ability to drive is absolutely awful. Don't. I'm going to protect my city at all costs, and if I have to put you in jail because of it. I'm going to have you sign. How old are you, ma'am? Okay, we're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign and reset. After that, I'll have you take your seat in the jury box. I'll get your bond conditions, no racing, reckless driving, anything of this nature. After that, I'll have you sign it and then you'll be free to go. All right. Good morning, Mr. Harvey. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was parked and observed a road rage incident occur. The officer observed the defendant's vehicle laying on his horn and speeding up to cut off another vehicle. The officer observed the defendant slamming on his brakes, and the driver of the other vehicle then attempted to drive around the defendant when the defendant cut her off again and slammed on his brakes, nearly causing her to drive into a ditch and nearly causing an accident with other vehicles. The officer then initiated a traffic stop and pulled into a nearby parking lot.
Mr. Harvey, I'm going to find that there's probable cause to go forward with your case. Patience. Patience when driving. And I'm going to have you sign a document promising me that you're going to exercise this patience and not drive in this manner again. And if I find that you do, I'm going to put you in jail. Do you understand? How many times do we have people on the road that sit there and get shot because of the incidents like, don't drive recklessly. Those conditions like we did in the other case.
Yes, Judge. Yes, Judge.
Harvey, we were going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. We'll then have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. Wait, does he have a Texas? Can you run his license, please?
Expired. I see eligible on our end. I can run it again.
Please. If you do not have a Texas driver license, then do not drive. I will have you sign an affidavit today with me promising me you're not going to drive unless you have a valid Texas driver license and liability insurance. It is your responsibility to reach out to DPS to figure it out. Do you understand?
Yes, I see eligible on our end.
Okay, I'm going to have him sign it. And then if you do, if you have a license and liability insurance, you can drive. If you don't, then don't. If I catch you doing it, it's not going to go well for you. You understand? Okay. You were charged with driving while intoxicated, second offense. The reason that we are taking you into custody now is that it looks like you're on probation for a felony retaliation case, which is now set at no bond. So we're going to do probable cause here today. If there is enough.
I'm sorry, I can't hear.
You're on felony probation. Looks like a warrant has been issued in that case. Bond is set at 0. So we'll do probable cause here. If I find probable cause, well, either way, we're going to, provide your lawyer today. But for now, we'll do probable cause on your DWI second. You're facing up to a year in jail and or a $4,000 fine.
Yes, Judge. The officer initiated a traffic stop in Harris County, Texas, after observing the defendant failed to yield to a right-of-way in an intersection and for driving with an expired registration. Upon contact, the officer observed a moderate odor of an alcoholic beverage and slurred speech. The defendant admitted drinking 2 beers and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 5 out of 8, and the defendant refused to do the one-leg stand. The DIC was read and breath was consented to. The results were 0.139 and 0.146.
All right. Have you seen whether she has a valid Texas
It's
driver's
not
license?
eligible, Your Honor.
All right. Ms. Gutierrez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. It is a condition of your bond, and you will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Now, I don't know if you're going to get out of custody, but if you do, you will be required to obtain a handheld interlock device that you're going to take with you to prove to me that you're not consuming alcohol. We will also be sending word to DPS so that every officer in this state knows if you're in a vehicle driving, you will be required to have an interlock in that car. So if they catch you driving hard that doesn't have an interlock on it, you're going to be going right back to jail. You understand?
Okay.
No alcohol, no drugs, and I'm going to randomly test you as well. We will provide you a lawyer today so that you can talk with this person to figure out how we go forward with the case. All right, come on, we'll have you sign this and then we'll have you sign your conditions, ma'am. Mr. Martinez, you're charged with racing on a highway. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 27, 2024, the officer was assigned to a traffic crimes task force and followed a group of 40 to 50 racers from 2400 block of Turning Basin to the 610 loop. The officer
Say 40 to 50 racers?
Yes, Judge. And the officer observed the defendant and co-defendant's motor vehicles in lane 1 and 2 slow down to approximately 30 miles per hour. And both vehicles took off side by side, trying to outpace each other at approximately 100 miles per hour. A traffic stop was conducted and the officer made contact with the driver, the defendant, and he was the sole occupant of the vehicle.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has a valid?
He's not eligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive, and I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing every time you drive. It's an offense in and of itself, punishable by up to 6 months of jail and a $500 fine. Do you understand? Do not drive.
I just found out that if you have 2 cars on your car,
Whenever you fill out the affidavit promising us you're not going to drive, we will get you to Victoria, sign a reset, and we're going to get you out of here. When you come back, please have a lawyer. Yeah, can you file no racing, reckless driving, and all that, please? Yes, Vic.
Okay.
So you're charged with failure to give information upon striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Yes, Judge. On December 28, 2024, the officer was dispatched to apartments in Harris County, Texas, in regard to a single vehicle accident that hit the mailbox of a residence. The officer observed the defendant's motor vehicle with heavy front end damage, but did not locate any driver or occupants inside the vehicle. During an inventory, the officer located the defendant's photo ID and Texas utility bill that came back to the defendant's name and address, approximately 1.4 miles from the accident. The registered owner of the mailbox came back to the defendant of the utility bill and his address. The officer went to the defendant's residence, noticed the garage door open and garage interior to the residence wide open. The officer made contact at the residence, wanted to make sure the motor vehicle was not stolen and wanted to make sure the owner of the vehicle was okay. The officer went inside the residence after knocking and announcing his presence several times under the community caretaking doctrine, and the officer made contact with the defendant asleep in the living room. The defendant woke up in
Whoa.
Yes, Judge. It was because they had.
Whoa.
Yes, the vehicle was damaged and he wanted to make sure the driver was okay. So he announced himself and went into the residence because the door was wide open.
Wow.
And then it was after that he saw the defendant asleep in the living room, and the defendant woke up and immediately said the car accident, that he did not cause any injuries or any trouble, and that he was driving his motor vehicle 2 to 3 hours prior, and that he was on his way to drop it off at a mechanic when his vehicle was hit. The defendant called the insurance company, and the defendant walked home because no one arrived on scene, and the defendant was going to pick up his motor vehicle in the morning. And the officer made contact with the complainant, who stated she heard a loud bang and observed damages, approximately $1,025.
So are you telling me that he did stay though?
No, what happened, Your Honor, is that he struck the mailbox at the apartment, and the defendant said that he called his insurance. No one came to the scene, so he walked home. And the officer, when he arrived, saw the empty.
Did he make an attempt to make a phone call at the scene to anyone?
All he said is that he called the insurance company. That's the only person that he had stated he called. And then after that, he walked home because no one arrived on scene. And then that's when the officer arrived and saw his empty vehicle damaged. And then he found a utility bill and the ID.
I have so many questions. I'm going to appoint you a lawyer, or you have a lawyer, right? Let's do this. I'm going to hold off on finding probable cause at the moment. Let me wait for your lawyer to get here. We'll revisit PC and here momentarily. Just go ahead and take a seat for me if you don't mind in the jury box. Yeah? Let's wait for your lawyer to get here and then we'll go forward. Sir, you were charged with unlawful carrying of a weapon and you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 27th, 2024, the officer observed the defendant's vehicle failed to maintain a single lane and veering over the left lane on 3 separate occasions. A traffic stop wasn't conducted, and the officer made contact with the defendant, the driver of the vehicle. The defendant advised he was unlicensed and that the motor vehicle was not insured. The officer observed a strong odor of marijuana emitting from the passenger area of the vehicle, and the defendant voluntarily produced a partially burnt marijuana cigarette and stated it was the possible source of the smell. The officer conducted a search of the defendant's identifying information, which yielded an open felony warrant for continuous violence, and a search of the defendant's left jean pocket yielded a clear plastic baggie containing a green leafy substance. The substance was identified as marijuana based on training experience. The defendant's motor vehicle was searched incident to arrest and yielded an unholstered AR-15 pistol on the front.
AR-15?
AR-15 pistol, Your Honor. And the defendant acknowledged ownership of the firearm and stated he used it for protection since his brother is a famous rapper.
Find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. Do you understand? You do not have a Texas driver license. You are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in this life. I don't care where you got to go. I don't care what you got to do. If you don't have a license and liability insurance, do not drive. Do you understand? How old are you, sir? What do you do for a living? Why?
The complainant stated he and the defendant had been at a comedy club and the defendant was drinking. An argument ensued and the complainant began gathering his belongings, and the defendant punched the complainant in the face with her left arm, making contact with the center of his face. The complainant said the defendant also slapped him with an open fist on his right cheek twice, causing pain.
Got it. All right, ma'am, I'm going to find that there's probable cause to go forward with the case. Do we know whether he wants to have contact or not? Have you guys reached out to
A
him?
rip was attempted this morning, but unsuccessful.
Okay, because I don't know what this person wants. I'm ordering you not to have
We have
contact.
a contact or no contact.
Stop. Just don't say anything. I'm just telling you what the expectation is, so you know, because if you violate these conditions or if you pick up a new case, I'm going to revoke the bond. We'll put you in jail. No more PR bonds. So no contact, no weapons. There is a protective order that has been issued in this case. Get to know it, because if you violate the protective order, they can file additional charges against you. You understand? So what we're going to do now is I'm just going to be signing a reset with Victoria.
In Allen's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The
But he
defendant,
had expired registration, right?
no, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there are other vehicles around the vehicle before the driver jerked back in the lane. So he went into the shoulder and there are other vehicles.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here elucidated is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of the safety of anybody else out there on the roadway. The shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to then stop him. This is insufficient information. And I would argue that there's not valid probable cause here on this case.
I think he has a valid point where, perhaps he's, well, I mean, I don't want to speculate, and you're saying, well, he's. Just do this way.
.06, Section A2, may not move from the lane unless that movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement was made unsafely, or that there was
Judge,
anything
I
unsafe
also
about it.
have the list of, where under Texas law, where it's permissible to drive on the shoulder, to stop, stand, or park, to accelerate before entering the main lane of traffic, to decelerate.
Let's do this. I mean, this is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go? Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time.
Yes, sir.
Right? And then give you time to take a look more. So if you need to, you too as well, if you want to try to find case law, let me just go through, because I have another lawyer that's waiting,
Absolutely.
Yeah, I'll help you out, but let me get through everything. Yeah, for sure. Good morning. Great to see you. How are you? Always a pleasure. All right. Mr. Barajas, you are charged with 2 counts of assault of a family member. You're facing up to a year in jail and/or a $4,000 fine on each. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you have the right to have an attorney present, if you cannot afford one will be appointed to you, sir.
It's my understanding that the state's going to dismiss one of the, it's the same, they just refiled it. That's my understanding.
Okay, good to know. Thank you.
If this doesn't work for you, we promise it.
Ready for PCP?
Sure.
On December 29th, 2024, the officer was dispatched to a residence in Harris County, Texas, and was met at the front door by the complainant. The defendant punched her in the back 3 times with a closed fist, and the complainant did feel pain from being slapped and punched in the back.
Okay, Mr. Vada, because I'm going to find that there's probable cause to go forward with your case. I'm entering now what's called a magistrate's order for emergency protection. This identifies Ms. Alvarado as a protected.
State's asking for 1,500.
Do you want a PR bond?
The court's going, I just didn't want to fight too much this morning, but.
Of course. Please.
Started on a cobblestone street.
The officers were surveying a known street takeover group in a large parking lot in Harris County, Texas, when the officers observed the defendant's vehicle spin its rear tires and do approximately 4 to 5 donuts in the pit, coming within 10 to 15 feet of other vehicles. Undercover officers kept their eyes on the vehicle until other officers were able to conduct a traffic stop. The undercover officers also identified the driver as a slim Hispanic male with curly hair. The officers observed the defendant in the driver's seat and the defendant admitted to doing donuts.
Right. Sir, I'm going to find that there's probable cause to go forward with your case. Have you seen if he has a valid license?
I'll run it, Your Honor.
Please. I'm ordering you as a condition of your bond not to partake in this type of behavior again. No racing, reckless driving, donuts, street takeovers. If I find that you do, I'm going to put you in jail. No more PR bonds. Do you understand, sir?
Yes, Your Honor. I apologize, it's loading right now.
Yes, no problem.
It's eligible, Your Honor.
Okay. You mind crafting those orders? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. We'll get you in the jury box. We'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Be careful. Don't drive like this again. Do you understand?
Yes, Your Honor.
Okay, ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 27th, 2024, the officer was dispatched to a disturbance at an apartment in Harris County, Texas. The officer made contact with the complainant, and the complainant and the defendant are cousins. The complainant and the defendant do not live with each other, and the defendant was staying with the complainant for a couple of days. The complainant stated she and the defendant got into an argument about the defendant's lifestyle. The defendant became upset and started to throw the complainant's belongings out of the apartment. The complainant and the defendant continued to argue, and the complainant tried to open the door to retrieve the belongings, and the defendant grabbed the complainant's arm, applying pressure and scratching the complainant's arm, causing a deep cut, bruising, bleeding, and pain. The defendant stated she had been arguing with the complainant earlier in the day, and the defendant stated she got fed up with the complainant criticizing her and asked the complainant to leave. The defendant stated the complainant pushed her and took her phone, and the complainant's small dog caused an injury, and the defendant did not recall injuring the complainant.
Do you know if alcohol played a part in any of this?
There's no allegations, Your Honor.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? These are your bond conditions. If you violate these conditions, a warrant will be issued. You will go to jail. No more PR bonds for you, ma'am. We will do that. We'll give you time. Yes, we're going to do that now. I'm going to have you sign a reset. Victoria will give you 30 days, but I'm going to have you also take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, man. All right? Please. Mr. Ware, you're charged with unlawful carrying of a weapon. You're facing up to a year of jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 28th, 2024, the officer was dispatched to a robbery that just occurred in Harris County, Texas at a restaurant. While en route, the officer observed males walking on the south side of the store where the robbery had occurred, matching the description the reportee provided. The officer called in an attempt to contact the two individuals and located the two males wearing dark hoodies, dark pants, and shirts in the store.
Got it. Mr. Ware, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. I'm now also giving you a curfew. I don't want you out in the middle of the night. And I'm going to put a monitor on your ankles so I know where you are at all times. Do you understand? If I find that you're a danger to my community, I'm going to lock you up and I'm going to make your bond so high. Do you understand, sir? No contact with the co-defendant in this case and no weapons as well.
Yes, sir.
How old are you, sir?
19.
Did you graduate from high school?
Yes, sir.
What are you doing with yourself now?
Not much.
Are you working?
No, sir. I was planning on going to the military. I was on to a military.
I want to know what you're doing with yourself. If you're working, if you're doing anything, because I want you to get a job. Too much time on your hands, you become self-destructive. You need something to do.
Forklift license. And I'm going to a class for forklifting.
Good. Get it done. You need to get a job, and I want to make sure that you're going to get a job. I'm going to provide you a lawyer today, but I want to see here within the next couple of weeks what you have done to get a job. If you've done nothing, life's not going to go well. Do you understand?
Sir.
In this life, you have to be productive. You have to either get yourself an education or get yourself a trade, a job, because I'm going to tell you now, when you turn 40, if you don't have a career, if you don't have an education, if you don't have anything, this life is not going to be a good one for you, because I'm going to tell you, life sucks without money. You need money. Otherwise, it's going to be just a rotten toilet of an existence. Do you understand? So we're going to make sure here you're going to leave better than you came. So you must either get a job or get into school full time. Do you understand?
Yes, sir.
I'm going to give you a lawyer today, and I'm going to bring you back in 2 weeks, and we'll see what you've done with yourself.
Yes, sir.
All right. Odd McLean.
Yes, sir.
Mr. McLean, you're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The officer was dispatched to an apartment in Harris County, Texas, in response to a disturbance. Prior to their arrival, the officers were told the defendant was in an altercation with the child's mother, was intoxicated, and had a firearm. Upon arrival, the officers observed the defendant banging on the door to his residence, and the officer told the defendant to show his hands, and the defendant ignored them. The defendant then pulled his handgun from his waist to show the officers that he had it, and then placed it back into his waistband approximately 4 times. The defendant eventually put the handgun down, but told officers they would have to tase him to get him to stop. The officers then attempted to detain the defendant, but the defendant continuously pulled his hands away and kept placing them in his pockets. The defendant was then tased twice, but kept putting his hands back into his pockets. The officers were eventually able to detain the defendant.
Did you say, initially you said he was intoxicated, right? Is that what you
Yes,
said?
he was intoxicated.
Okay. Mr. McLean, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs and not to be in possession of weapons. Do you understand? What do you do for a living, sir?
Photographer. Do photography.
Okay. What kind of income do you have from photography?
Income coming in. What you want to know, monthly? Or?
Yeah. Do you have the ability to hire a lawyer?
Yes.
Okay, we'll give you time. So I'm going to have you meet with Victoria. We'll have you sign a reset. I'll have you get with Fleischer for your bond conditions. And after that, you're free to go. All right? Please. Okay. Ready? Yeah, sorry to keep you waiting.
If it is invalid, we promise a tenfold refund. This denture can be successfully worn in just 1 second and is suitable for everyone. Whether you have complete teeth, partial missing teeth, or no teeth at all, you don't need adhesives, dentists, or appointments. Just soak it in hot water to activate the elastic material, bite it to fit your unique oral shape, and within a few minutes, you can have brand new dentures. My friends all say they look very realistic, just like dental implants. It fundamentally solves the problem of missing or loose teeth, as well as various issues such as sensitivity and difficulty chewing. Amazing! Soft silicone is suitable for any oral condition. Very durable, it feels like a natural part of your mouth. It has obtained international standard certification, so there is no
How are you?
Do we have Zuberi, right?
Right.
How are you?
Good, good, man. We have a.
We've been working hard. The case was filed late April. He had a retained lawyer in the beginning. He came to me middle of June. I subbed in late June. I had a couple settings.
Where do you want to go? What do you want?
We're asking for about 30 days to flush some stuff out. And I think ultimately, what I'm slightly disappointed with is the way the case was presented by the agency to the DA's office. It's not their fault. We've been put in a time crunch where we got to November and began to run up against your 180 days. And I think we all kind of realized the agency didn't bring over what they needed to bring over.
So are you still lacking stuff?
I think we're all in a position where it's less, some of the initial discovery is complete, but because we're all working so hard, there's some subsequent discovery that needs to be done based on some things that have been said. And so Kelsey's been great. She's working hard, talking to people.
But I mean, what do I need to do? Because we're now at 240 days. We're still missing stuff. It's unacceptable.
I would suggest this is one of those moments where I would say we've all been doing this a long time. If you just trust me, I'd say we really just need 30 days to work on some things and then come back, and I think we'll be in a better position then to know with clarity whether we're working this out or not, and we need a trial date.
Well, then I'll give it to you, Lon, but the next setting is clear trial, you know? Like, that's it.
And I appreciate your position is like, hey, look, I've got and have an idea of when and how I want to move things. Every now and then things get messy. This one's gotten a little messy, but
typically when we face this type of dilemma, what I do is I order them and I subpoena the people who have.
Yeah, this is a little different than that. This is different. And if we were in one, and I think you did that back in November because there were some screenshots or something that maybe weren't complete yet. And then so you asked for a compliance hearing, and then some more information was provided, which again really only happened because the agency in the beginning didn't have a detective assigned to the case to really work it up and bring it over. Like, I'm used to a small town, like detective work. This didn't happen here. And so a lot of it's been thrust in their lap, unfairly probably. And so she's good, we're all good. Got good
Right,
lawyers,
so-
good lawyers working on it. If you give us 30 days.
I'll give you the 30 days, but at the next setting, it's clear trial. I mean, it's it, because by then we'll be, 275. So we're close to.
Subtract 60 that I wasn't on it.
Yeah, I mean, and that's why I'm giving you the benefit of the doubt.
3 for 1.
Okay, all right, we got it.
Thank you, sir.
Okay, sure. You were charged with driving while intoxicated, first offense.
第一个指控是您被指控醉驾，
It's elevated to a Class A misdemeanor because of the high blow.
因为你吹气的时候，它的这个指数比较高，所以它的这个罪行有就指控加重，成为了第一级的轻罪。
You were facing up to a year in jail and/or a $4,000 fine.
您将会面临高达1年的服刑，或者可以或者是$4000的罚金。
We are going to do probable cause. You have the right to remain silent.
你有权利保持沉默，我们将会做一个可能性的证据。
Anything you say can or will be used against you.
你所说的话可以，也可能将会对你不利。
Officers were dispatched to a major crash in Harris County, Texas.
在德州 Harris 县，警官被派遣到一个汽车事故现场。
Complainant told officers that he was sitting at a red light and was rear-ended by defendant.
指控者告诉警官，他当时在红绿灯那边等红灯，最后被一辆后面的车追尾。
Upon arrival, officers found the defendant standing next to his car.
在到达现场的时候，警官发现被告人在他的车旁边站着。
Defendant repeated to them that the accident was his fault.
被告人一直 不断的告诉警官，这次的事故是他的错。
Officers observed bloodshot eyes, slurred speech, strong odor of alcoholic beverage, and poor balance.
警官当时看到他的眼睛通红，说话的时候不清楚，同时他平衡非常有限，有一些酒精的影响。
The defendant admitted to drinking 2 beers.
被告人承认他喝了2瓶啤酒。
Standard field sobriety tests were conducted.
标准的现场酒精测试执行。
6 out of 6 HGN.
The interpreter requests a repetition.
6 out of 6 HGN.
HGN 的指数是6。
8 out of 8 walk and turn.
走路，所以他的驾照是有资格的。
Mr. Luo, I'm going to find that enough probable cause exists to go forward with your case.
罗先生，我觉得我们现在有足够的证据，可以认为我们可以认定你是有罪的。
I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs.
Your Honor, the interpreter needs to clarify one thing. So the interpreter requests a clarification because there is some I couldn't hear some of the words. So if it's failed to the test and the consumption of alcohol, his bond is ineligible?
So what happens is if he tests positive for alcohol or illegal drugs, I will revoke this bond and put him in jail.
Okay, that's what interpreter was saying. Okay, 所以如果要是您的酒精测试是阳性的，或者是您喝了酒的话，那我们就会把您直接就进监狱，然后呢，您同时也没有保释金了。
We are going to reset your case to give you time to hire a lawyer.
我将会给你时间去寻找律师，同时我们也将会让您的出庭日期重新安排。
Do you have any questions?
有什么问题吗？
因为我有3高，我从来不喝酒的，只是因为那天过节日，过圣诞节我喝了以后，都是已经5、6个小时以后才开的车，但是我不知道为什么这个车是这么高。我从来因为我有3高，每天需要吃药，我根本就不喝酒的人。
Okay, so I have high blood pressure, diabetes, and high cholesterol, so I hardly ever drink. And that was during the Christmas holiday season. I drank very little.
Ma'am, I don't want to talk about the case.
No, that's the interpreter's job is to interpret for it. So it's not the interpreter interpreting, it was Mr. Luo was talking.
I don't want you to say it because he has the right to remain silent.
Okay.
Anything he says, they can use it against him. And I don't want him to say something that hurts the case. I'm trying to prevent that conditions, understanding the bond. You will sign a paper indicating you understand your bond conditions.
你将会签个文件，上面会表示你已经了解了保释金的条件。
And then you're free to go.
然后你就可以走人了。
Please.
可以吧？
Go for it.
Well, that's where I'm going to end it for today, ladies and gentlemen. Tomorrow is Judge Boyd.
You flip it, yeah. Keep coming with it. Keep coming with it. Keep coming with it. Place your bets on us. Get your money and flip it. Bring a friend and come along. Don't be taking too long. The vibe's too strong. If you don't know how to move, then we moving on. Ain't no way rhythmic feet up in this place. If you can't catch the feeling, then get out the way. I've been reeling and fish from the lake. They keep saying I'm down to earth, but I'm really out of space. All these women aliens, super foreign, so exotic. Hop in the Mercedes Benz, and I got them crushing like ice pouring the bub. It's overflowing on us. You drop it, then pick it up. I think I'm falling in love, but shawty, this isn't what you probably